attitude is that a woman who's made it that far has had copious conversation with folks, counsel. They've made it far enough to appear in a courtroom. To me, that's a pretty arduous journey for someone who probably has a pretty significantly traumatic background who found themselves there. For me, any young woman in that situation, I would hope that a judge not only would approve their request, but would provide no pushback and provide no condescending, paternalistic or maternalistic guidance, because I think that woman has already heard it and already arrived at a decision that's very difficult, that she's navigated a lot of challenging routes for a young woman to get to that point. And I'm wondering, would you be aligned with my philosophy that we don't push back? And if you're not, would you be willing to recuse yourself from such a situation?
I would. First of all, I think I would treat everyone, particularly a young person, with dignity and respect. I would never be condescending. Mm-hmm. And I would respect their rights and my expectation. I know there's a process they go through to get there. I would anticipate allowing them to go forward with the health choice they want.
Okay. I appreciate it. Like I said, I apologize for being difficult to reach.
I know you're busy.
Follow up with anything else I'd like to talk about, and I appreciate the time.
Thank you, Counsel. Counsel Jacob.
Hi, it's good to see you. I appreciate that you came out and spent a good amount of time with me, and we talked about a whole lot. I wasn't planning to, but I kind of, just based on your response just now, I want to continue the thread about abortion access to minors who might find themselves in Superior Court. You said, you would be supportive when it would seem appropriate. I'm just curious what instance might be inappropriate.
I can't think of one of them. That was just a word choice.
Okay. Well, because I was like, do you think there are times when it would be inappropriate to support?
I can't think of one, no.
Okay. And then the second one actually was sort of also came from Councillor Ionella's questions, but on this issue, time is of the essence in those appeals, right? Because there's development happening, and the delay can have medical consequences for the mother and whatnot. So I was curious about your thoughts about how you would approach it from the standpoint of scheduling, and if a continuance was requested in an instance like that could have a serious consequence for the applicant.
Well, obviously, if there were a medical health or welfare issue, that would trump an attorney's schedule and move forward.
Okay, I appreciate that. And I literally wasn't planning on asking either of those questions, but sort of bubbled up from the conversation. We talked about a little bit, and you talk about in your application, and in your application, you're kind of framing it in the context of district court, but for Superior Court, I'm curious to hear more about your thoughts on diversionary programs, which ones you are particularly inclined to want to make use of, if there are areas, opportunities to innovate around diversionary programs in Superior Court, what your thoughts might be around that.
Well, typically diversion is the decision of the DAs. So usually by the time there's a decision to divert, it's usually going to happen at the district court level. If they decide that a case warrants being indicted, it's going to move up to Superior Court. So it's probably a little too late for diversion. But obviously, I think a judge has discretion when he's talking about thinking about sentencing to think of, like we talked about, probation with programs, counseling, that sort of stuff as an option. So I don't see diversion being applicable in the Superior Court, but it's something that's used more often and should be used more often than it is in the district court.
So it's interesting you say, because we in Western Mass we actually have some Superior Court diversionary programs. One that I am more familiar with than others it's called the Emerging Adult Court of Hope, and it is a collaboration between the court, the DA, and actually also a nonprofit, an area nonprofit that coordinates and collaborates and helps with some of the programming and assessments and then meeting the needs that are revealed. And but it bubbled up from the Superior Court, so it was sort of the lead was all that to say, I think there probably are far fewer than on the district court side, but there are opportunities. I'm just leaving that with you to think about. And
When I've had clients that have gotten to diversion, it's usually worked out very well. They avoid criminal record and they usually turn things around. So I'm a big proponent of diversion.
yeah, that's sort of what that court does. It's fairly intense. Graduates then are not immediately given sort of expungement, but after 5 years. So they do a whole intense program, and then if they can stay on the path of success for 5 years, it just poofs off of their record, which is especially when you're talking about young emerging adults who maybe made horrible choices for reasons. All right, I appreciate that. I wanted to follow up with you on so we had a conversation that bubbled up out of the golden rule in your application. You talked about one, treat people with the way that you would like to be treated as a way to be respectful, and I do appreciate that point of view. But we had a conversation around sort of a broadened cultural humility around that thought that not everyone wants to be treated the same way, and how you want to be treated might actually be harmful or hurtful to someone who feels differently.
Sure.
And I just want to kind of balance that with the concept of just gender bias in the courts as an example. I think there's so much bias in our courts that we could talk about, but I think you might have an interesting perspective having a judge in your home who might have experiences. I'm totally making assumptions, not with any evidence having come from our conversation, but having said that, I have had conversations with female judges who even they have experienced gender bias in their own court, where male attorneys are interrupting them, for instance, or just responding to them in a way that is just inherently disrespectful and probably from a gendered, like microaggressional kind of a way. I've absolutely had those conversations with female attorneys who've had experiences, like just from attorney wellness in the courts. And I'll add the next layer of just looking at the statistics in our state around incarceration and parole as well, that there's clearly a gender bias impact in addition to racial bias. Like they kind of intersect, right? So there's intersectional bias, but it seems like from looking at the data that there's sometimes harsher sentences happening for women, and especially when you start breaking it down, women of color. And all of that to kind of give it to you with sort of a question, but what I really just want to hear your response to those thoughts and your intentionality around how you as a judge in Superior Court how would you ideally hope to affect positive change around some of that?
I remember our conversation, and you made me stop and think, and I guess that's a good thing. And obviously there's been a lot in recent years on implicit bias. I know from speaking with my wife, the district court, I'm sure the Superior Court has done a lot of training, so we all know that everyone has biases. And I think employing the 5 tactics that are in the jury instruction is great. Think about what you're doing. Slow down. Think about, would you treat this person who's before you differently if they were in a different class or a different group? So I think those things are important. Again, I try to, and obviously we all have to recognize there's implicit bias in everyone. I try to treat everyone as fairly and equally as possible. And that's the best way I can answer that question.
Okay. All right. Well, I appreciate it. I have no further questions.
Thank you. So Devaney.
Thank you. How nice to see you again. Thank you for all that time. I really like the bells from Wamble.
They were very good. I enjoyed it.
And I always say to the nominee, it has nothing to do with my vote, okay? Whether you get it or not. But anyway, I'm just very impressed. And I love that you have been a lawyer for 34 years, because I look for life experience to bring forward, and you have that. And I like your litigation work, 60% criminal, 40% civil. That's great. Now, I want to ask you, you have been there to see the changes in court, changes in law, changes in society. So I think you bring that to the court. So what have you seen, the changes in 34 years, and how you have to be prepared as a judge to accept all these changes?
Well, I think one of the biggest changes is in technology in the court. And, I'm continuing to practice. So clearly you look back, there's been changes. I think I've absorb or embrace those changes on a day-to-day basis, and I would continue to do that as a judge. So.
Right. Well, we talk about, and you have talked about the volume of criminal cases in the Superior Court. And so tell us what changes you would like to see in using the diversion program. Could it be better used? Just tell us about that.
I think for the most part, I'm a big fan of both the district court and the Superior Court. I think they do a great job. Obviously, there is a lot of cases going through. I practice primarily in Essex County. I think, as I said earlier, diversion, if available, or programs or treatment are something that is a useful tool and should be applied because it's the right thing to do in many cases. So I would continue, I've advocated for that as an attorney, and I would continue to use it as a tool as a judge.
What about, I'm just thinking, in the early stages of litigation, do you think that's where it should be started to look at these diversion programs?
Usually, whether it's in the district or Superior Court, diversion is usually something that the DA's office will screen to see if someone, based on their record, the charges, if it's appropriate. I've gone to times more in the district court, go to speak to the people on the diversion program and say, hey, I've got this young person who doesn't have much of a record. What do you think? Can we screen them and get them in there? So it's something that is typically done early on in the program.
Well, you've practiced in New Hampshire also, so you learn how the different changes are from New Hampshire to Massachusetts. They use mediation a lot, don't they, in New Hampshire?
They do, and Massachusetts does as
Okay,
well.
now tell me how you have used mediation in your practice.
Well, I've sat for the past 15 years as a conciliator in Essex Superior Court. I volunteer my time to help the court, deal with some congestion of civil cases, and then representing clients. I've often cases have agreed the parties go to mediation as a way of resolving the case.
So to settle a case, it has been successful?
Very successful.
Okay. Now, I'm very interested in writings, and you love to write, so you should be in the Superior Court because you need to write. You did have a writing about the review of the Attorney General's decision on suspension of deportation proceedings, and that's very timely. So tell us about that.
That actually goes back to 1989 when I was in law school. So I'm not sure how timely it was. It was when I was on a journal at Suffolk Law School. That was one of my papers
you were ahead of the game.
I don't know about that. You're better than I am. I don't even know if I could tell you what I wrote about. I can tell my resume, but.
Okay. All right. How has the changes in our society in your 34 years? How has that changed? You've been a lawyer, and what do you see as a judge?
Well, I think, obviously there's been a lot of changes. That's, something that I take into consideration, impact me as a lawyer, as a husband, as a father. And I think it's something that I would obviously take into consideration and be a part of me if I'm fortunate enough to be confirmed and sit on the bench.
And tell us about your pro bono work.
Well, I've done the court-appointed work for years. We do get paid at a reduced rate, and I volunteer my time as a conciliator for the Superior Court. And I've had cases in the past where friends or people we know in the community, typically in Lawrence, will say, "I've got this situation with a young person. Can you help them out?" And I know my wife did it for years, and I've done it, help people out for no fee because it was the right thing to do.
And that's what I see in my years here, that when we have a young person, 40 years old, they don't do pro bono. They don't have time for that. And I see someone like you with your experience that you'll take the time out and you know that that person can afford a lawyer and you step in. Those are the kind of things I look for. In a rounded person, you've worked in your community, you have volunteered. That tells me you're a caring person. And the cases that you've had, and I've looked at all of them, I see compassion, and that's what I vote on, compassion, and that's very important to me. So now, you have applied twice. Tell me about that experience. How far did you get?
The first time I had a interview with the JNC, didn't go any further than that, and then I applied one other time, and then this time, thankfully, got this far, so hopefully we can continue.
That's kind of disappointing, because I've heard from former, applicants that they said, "Oh, I was so sure I had it, and I met with the governor and didn't get it." But I got to tell you, this administration is bringing us really like you, qualified people. And probably when you applied, a political person jumped the line. That's how it goes. But I'm glad
Can't speak to that, but thank you.
you kept applying. I mean, I have voted for people who have applied 3 times. One time, recently, a couple of years ago, 5 times he applied, so qualified, you know, good record. But it depends on, you know, who's out there looking for that job. But I have to tell you that I like the age, I like the experience that you're bringing, and all of it that makes the whole person, because I vote on the whole person. That's why I meet with everyone from the whole board to judge, because I don't want to come in here and just look at a paper and see you and that's it. So I really know, I feel like I know all your family. And the funny thing was that when we talked about it, our ethnicity was exactly the same. I couldn't believe it. I mean, you got the Italian side, and I got both. I got Evelino, I've got Sicily, and then you're Irish. My late husband's Irish, and a Scottish grandmother. I couldn't believe this. And that's not why I'm supporting you. Know that.
I'll take it. I'll take it.
But it is amazing, but that's what I see. I see the whole person. And when you talked about your family, how important that was, that means a lot to me. And so, you know, I'm just so pleased that you were persistent and you applied again. And I want people out there to know, please do it. I had, about a month ago, I had a forum, and I invited some of the staff of the governor, and I had the chair of the Judicial Nominating Commission and judges. And it was the largest amount of people that have come since the pandemic. And I wanted these people to know this is an open process. This isn't for the governor's next door neighbor. It isn't for, you know, the lieutenant governor's coach of her kids. This is different. And we're getting people that are qualified. And so I want them to apply. And I think they went out there feeling like I have a chance now. And so I wouldn't have done this, to be honest with you, in the last administration, because I couldn't guarantee that any of them would have a chance because of the political atmosphere, but it's different now, and I couldn't be more pleased working in this administration. So I'm glad you did apply again.
Thank you.
And I thank you, and I thank the governor too. So, you know, I think that I brought some of the things that we brought up when we met privately, and my councils have asked good questions, and I'm really so pleased. I really am. So thank you for applying.
I appreciate it. Thank you, Council.
Thank you.
You know, once again, I find myself in a position that I often find myself in. Not too long ago, I was in front of Judge Lawrence Pierce in the Superior Court. Many, many decades ago, we worked together. And they called my case, and I stood in front of him, and I looked at him, I said, you know, I was just telling the DA how every time I go into a courtroom these days, I'm the oldest guy in the room. And I looked at him and I said, except today. He then challenged me to a race around the courthouse. And I am the oldest guy in this room. Now, I'm getting away from Superior Court work as I get older. I've done a lot of it in my career. I've tried many, many cases in there over the years, but you've seen many lawyers, I'm sure, over the years, they tend to, it's almost like they go to the appeals court, not that easy, but it's kind of like that. But but it's still extremely important to me who's on the bench. And, you know, we have a lot of very, very good Superior Court judges sitting on the bench who work very, very hard. One of the problems they've had lately is the lack of sessions for civil sessions. And I suspect when you go in there, you're going to be spending a lot of time playing catch up on those. How are you going to handle that? They're way behind on civil cases.
Well, if I'm confirmed, I look forward to it. You know, I've done.
I think you're getting confirmed. You're not a count. I think I heard 1, 2, 3, 4 right there. So
I've never been afraid of hard work. You know, I got a good work ethic from my parents. I'm willing to dig in. I've dealt with all types of civil cases over the years, a lot of complex litigation. I'm sure there's a lot of summary judgment motions I'm going to have to read and be happy to do it.
well, let's talk about summary judgment motions. You think they should be allowed very often?
I mean, it depends on the case.
Well, you think it should be rare? Don't you think people should have their day in front of a jury?
If it's a negligence case, usually it's unlikely to be allowed that it should have a chance to have their day in court. Absolutely.
Even in a contract case, shouldn't people have their right to their day in court?
Absolutely.
I'm not a big fan of summary judgment motions, probably because I'm mostly the plaintiff, but
So am I. So that's what I know. That's what I
I
understand.
know your history. I know your history. Anyway, it was, you had a lot of insightful comments today, and I'm certainly going to look forward to voting for you in 2 weeks. I will not be putting your name in nomination. Hopefully Council Duff feels better. She'll be the one doing that. And I look forward to voting for you.
Thank you very much.
That's it. We're done. The break and leave. Get out.